Mr. Speaker, I'm pleased to lay before this Honorable House a bill entitled the Matrimonial Clauses Faultless Divorce Amendment Act 2022. This bill amends the Matrimonial Clauses Act 1974 to reform the current legal process for obtaining a divorce, nullity of marriage, or judicial separation, and for related matters. The bill represents the first part of a raft of reforms aimed to modernize matrimonial law in Bermuda. The amendments proposed in this bill are aimed at reducing conflict between persons petitioning the court for applying for divorce, nullity of marriage, or judicial separation by reframing the prescribed procedures and formalities affecting the most contentious parts of the court process. This bill, Mr. Speaker, will principally usher in a new and much-needed legal process which replaces the requirement for persons seeking a divorce to satisfy the court of irretrievable breakdown of the marriage by proving evidence of conduct, sometimes referred to as separation facts, during the divorce proceedings. The proposed amendments will allow instead either party to a marriage to apply for a divorce and provide a statement of irretrievable breakdown as conclusive evidence that the marriage has broken down irreversibly. Mr. Speaker, these kinds of reforms to matrimonial laws are commonly referred to as no-fault or faultless divorce regimes. They are so called because they remove the unhelpful blaming and shaming associated with having to prove in court that the conduct of one of the parties is a cause of breakdown of the marriage. Mr. Speaker, to contextualize where the current law stands, the legal process for divorce can be initiated by one party to the marriage, the petitioner. The other party, the respondent, has then acknowledged that they have received or been served with the petition and state whether they disagree with the divorce and intend to contest or defend it. The current law requires a person seeking a divorce to satisfy the court that the legal test of irretrievable breakdown is met by citing in the divorce petition one or more of 5 facts as referred to in the statute. 3 facts are based on conduct, namely adultery, behavior, commonly referred to as unreasonable behavior, and desertion. 2 of the prescribed divorce facts are based on a period of separation prior to filing the petition for divorce, 2 years if both parties consent to the divorce, or 5 years otherwise. Under the existing law, the court can hold that the marriage has broken down irretrievably only if it is satisfied on the evidence presented that one of the 5 divorce facts is proved. If one of the 5 facts is determined, the court will grant a decree of divorce. Mr. Speaker, now that I've laid out the technical requirements of the existing processes, it is easy to see that it is not at all straightforward. The process can be quite intimidating for laypersons to navigate. For this and other commendable reasons, faultless divorce regimes have been implemented in several countries within the Commonwealth to modernize and streamline the legal processes for divorce, judicial separation, and nullity of marriage. The amendments proposed in this bill are modeled after the United Kingdom's Divorce, Dissolution, and Separation Act 2020. Mr. Speaker, faultless divorce proceedings substantially reduce the possibility of one of the parties contesting the divorce. This is because the newly proposed statement of irreparable breakdown will be taken as conclusive evidence by the courts that the marriage has broken down irretrievably, without having to delve into the personal indiscretions or behavior of the parties. Divorce proceedings will still be able to be challenged for reasons such as jurisdiction, validity of marriage, fraud, and procedural compliance. Mr. Speaker, the stress, effort, and cost for persons to show fault is thought to be unnecessary, as it often conceals the real reason for the breakdown in the marriage and can be a factor which discourages spouses suffering under domestic abuse from filing for divorce or separation in the first place. Mr. Speaker, socially, we are all too familiar with the associated stresses within divorce proceedings which can cause angst, conflict, and disagreement in families. The parties tend to become embroiled in the contentious partisan features of the proceedings, often demonstrating an inability to look at matters objectively in the interests of all the parties concerned, especially the children. This means that at an already stressful time in their lives, the current process incentivizes parties to focus on negative conduct and make allegations about past events, potentially introducing or aggravating ongoing conflict. As a result, divorce proceedings can become drawn out overly contentious and painful, producing indifference and acrimony within the family. The resulting impact often strains a family's finances and health and prejudices any hopes to maintain amicable relationships moving forward. Mr. Speaker, the amendments provided for in this bill remove some of the structural hurdles for applying for and obtaining a divorce, nullity of marriage, or judicial separation. For example, by introducing new minimum time periods into the divorce processes and updating archaic terminology with modern, plain English terms that are easily understandable, such as applicant, divorce order, and divorce order final. Mr. Speaker, the bill revises statutory timelines for the procedural steps required to obtain a divorce or nullity of marriage. Revised timelines will help streamline processes and prevent case backlogs, as well as unnecessarily protracted proceedings. Adjusting the time periods will not reduce the accessibility for parties to reconsider or change course during divorce, nullity of marriage, or separation proceedings. Under the revised time periods, an application for divorce will take a minimum of 20 weeks, which equates 5 months, to obtain a final divorce order from the court. Applicants seeking nullity of marriage will have between 4 and 12 week time period before nullity of marriage order is made final. Mr. Speaker, provision is made in the bill for the minister, after consulting the Chief Justice, to shorten or lengthen these statutory time periods in the divorce process by way of an order. The courts will also be empowered to shorten time periods in a particular case by applying its judicial discretion. Mr. Speaker, reducing the legal and procedural complexities directly translates into a reduction in legal costs for parties and simplifies the process for litigants in person who may not be able to afford legal representation. Such savings may then be used towards sustaining the family members and children in a post-divorce environment. Mr. Speaker, the government is mindful that the present bill prescribes measures that are expected to reduce conflict between parties, and by doing so will reduce harm and trauma caused to children who live through a parental divorce. Other areas where we are instituting practical changes to the process include establishing an easily accessible online platform to facilitate divorce and separation filings. This platform will have informational content to assist parties with understanding their rights, obligations, and the judicial process. Mr. Speaker, should these amendments become law, there will indeed be space for more amicable outcomes for families facing marriage breakdown and divorce. The legal process, in and of itself, will no longer contribute to amplifying or adding to the conflict between the parties in the ways we know that the existing court process may cause. Mr. Speaker, I am confident that the proposed bill is timely and sufficiently fulsome to garner cross-aisle support. The provisions of the bill have been seen by the Matrimonial Bar Subcommittee of the Bermuda Bar Association and the Family Court, who provided meaningful, constructive comments on an illustrated draft of the bill. Overall, the bill accomplishes an improved framework for faultless divorce in Bermuda that can be further developed as we monitor and evaluate the emerging trends after implementation. Whilst this bill goes a long way in intended outcomes, as indicated at the onset, this is the first part of a raft of reforms aimed to modernize matrimonial law in Bermuda. Ensuing phases are expected soon in this continuum. Mr. Speaker, I look forward to debating the provisions of the bill and its benefits as the bill advances through the legislative process. Thank you, Mr. Speaker.